Good afternoon and welcome to the Post Advisory Committee meeting. My name is Jason Salazar. I'll be serving as the acting chair today. If you would please rise for the flag salute and remain standing for a moment of silence. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Since the last meeting on March 2nd, we will be recognizing a moment of silence in honor of U.S. Border Patrol California Agent Daniel Salazar, end of watch May 17, 2022. Thank you. You may be seated. Okay, can we have a roll call of the committee members, please?
Allen,
Present.
Banning,
Present.
Beauchamp,
Present.
Bernard, DiBasilio, Oborn, Salazar,
Here.
Schmidt, Spry, here, Swift, Viramontes,
Here.
Waltz, and Young. Thank you.
Okay, thank you. This time I'd like to take a moment to introduce Post Executive Director Manny Alvarez, as well as Assistant Executive Director Maria Sandoval. I would also like to recognize a new member to the Post Advisory Committee. That is going to be Walt Allen, who is representing CADA, the California Academy Directors Association, and welcome here to the Post Advisory. Would you like to say any words?
It's a pleasure to be here, and I know this committee does a lot of good work, and I'm looking forward to working with you and the Post staff.
Thank you. Welcome. Okay, at this time, we will have public comment. This is time set aside for members of the public to comment on items on the agenda. The chair will manage the public comment period in deference to the committee's workload and meeting time constraints. Up to 15 minutes is allotted at the beginning of each meeting for public comments on items on the agenda. Members of the public who wish to speak are asked to limit their remarks to no more than 5 minutes each. If we have many people who wish to speak on the same topic, I, as the chair, may intervene and will ask that you limit your remarks to no more than 1 minute. Pursuant to existing commission policy, the chair may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. Is there anyone who would like to just address the committee during public comment at this time? Okay, seeing none, I will move to item number A, approval of the minutes. This will be approval of the action summary and minutes from the previous committee meeting, which was held on March 2nd of 2022. Are there any corrections, or can I get a motion to approve the action summary and meeting minutes from the last committee meeting?
Motion to approve. I don't know how to say it. I said it wrong. Please correct me.
Motion by Julie Spry. Can I get a second?
Second.
By Eric Schmidt. Okay, all in favor? Signify by stating aye.
Aye.
Any opposed? Okay, that will be approval of the minutes from the March 2nd, 22 meeting. We'll now move on to section B for announcements from any of the committees, committee members. At this time, are there any announcements from committee members? Okay, seeing none, we will move quickly to item number C. This will be a review of the commission meeting agenda. So we have two agendas to review for today's meeting, one for tomorrow, which is March 25th for the SB2, and then the regular post-commission meeting on March the 26th. At this time, I will turn it over to Assistant Executive Director Maria Sandoval.
Thank you and good afternoon. We've had a couple of last minute requests for presentations. So I'd like to call up these Bureau Chiefs, Jackie Nelson and Scott Campbell, who will talk about the adoption on Commission Regulation 1205 serious misconduct.
Good afternoon, and thank you for inviting us to speak on this very important matter. I first want to start by saying welcome to Walt Allen. I've had a very good working relationship with him, and I'm very excited that he'll be serving on this committee moving forward. So 1205, I just want to give you a little background on what went into the development of 1205. So to form the definition of serious misconduct, Post received input from two separate varying stakeholder groups. One was the law enforcement committee, and one was with various advocacy groups. So the content from those two meetings were presented to commission during a special session in April. And as a result of that meeting, a proposed definition was formed by the commission. So in advance of us bringing that definition to commission tomorrow, or putting it out for public comment, we sent that proposed definition through the Office of Administrative Law. And we also sent it through our agency legal counsel. And as a result of that, there were some issues that occurred during that review that prompted staff to have to make modifications to the proposed language. So tomorrow, what you will see is that we will not only present the verbiage as it exists in SB2, the actual text, but we will also be providing the text as proposed by commission from back in April. And then we'll be doing a third text, which will include the proposed language by staff for the commission to vote on for the final definition of serious misconduct tomorrow. Questions about that?
Has there been any public comment received on any of these as of yet?
So that's a great question. So public comment went out on 20 of the 22 regulations. Serious misconduct is one of the ones that public comment will come out after it is voted on by commission tomorrow. So it has not been open for public comment as of yet.
And after public comment is received, will it come back to the commission for final adoption, or is tomorrow the final adoption?
No, tomorrow, if it depends. If there is significant changes that will result in the definition based on serious misconduct, then that will have to come back for commission for approval. If not, then we will be able to amend it as is tomorrow, or adopt it as it's voted on tomorrow.
Okay, thank you. I just want to thank the staff's time. I was able to catch most of the commission meeting when they discussed the serious misconduct and know a great deal of thought and work went into that. And we appreciate that from the staff and from the commissions. Is there any additional comment or question from members of the advisory committee?
I'll follow with Jason on. Thank you for that large amount of work you guys have done. In March, we discussed a lot of language and that comes with this. And would that also be part of this portion as it pertains to certain groups, or and the list that was given to us in March? Is that going to be also, does this be part of it?
No, so those two lists that we provided with the two different stakeholder groups was
Yeah.
presented to them in April. So moving forward, we will not be utilizing those lists because they've already been evaluated and analyzed by the commission. So those will not be pertained or contained tomorrow as we move forward. Does that make
Okay.
sense?
Yeah.
Okay.
I guess because it was unclear in March, so maybe I might have missed something. I just wanted to see if it was included or not.
Do you?
I'm good. Yeah.
Okay.
Okay. But once again, thank you for all that work. You know, I know that I spoke to several people aside, and I know it's been put through the ringer, so I appreciate everything you've done.
Oh, thank you very much.
And also coming to us with the information, even if there's small amounts of response back. We truly appreciate it.
Thank you.
Any additional questions or comments from committee members? Mr. Allen?
being the new person on the block, I'm curious about the fact that as we move forward with the adoption of SB2, is there going to be a move from the legislators' part to fund it and the employees? I was just curious.
Yes, there is, and maybe if I could suggest, I have an update that I could give you guys an overview of SB2 from the last commission meeting to now, if you would like, and that might prompt some of these questions and provide answers.
Thank you.
Would that be okay? Thank you. Bear with me one moment, please. Let me find my notes. Okay. Okay, so since our last commission meeting that we held, the actual official, not the special meeting, the official meeting that occurred in March, this is an update since that time. So this is not going all the way back, but since our March meeting. So now we have 9 full-time personnel working on the transition team, including the addition of a second bureau chief, Mr. Scott Campbell. Yay. So the additional staffing to this project has been significant to allow us to be able to successfully reach the goals that we are quickly coming up upon. So first, and most importantly, is the budget change proposal submitted by Post to support this initiative has been approved. So the total funding amount for FY 22-23 is $22.6 million. And moving forward for 23-24 and ongoing will be $20.6 million to support this initiative. So the number of additional positions we've received pursuant to this budget change proposal is 127 positions, which is nearly doubling the existing size of Post as we are today. So an overview on what some of these positions will make up will be the new division, which will be called the Peace Officer Standards Accountability Division. This division will contain 5 new bureaus, which will include an Intake and Disposition Bureau, a Certificates Bureau, and 3 Professional Conduct Bureaus, which will encompass the investigative component. Additional staffing will include an Assistant Executive Director to oversee the new division, a legal bureau consisting of a chief counsel and 7 attorneys, additional staffing for the executive office, human resources, computer services bureau, administrative services bureau, and strategic communications and research. All of these positions are going to be relevant to being able to fulfill the workload that's associated with SB2. So we have completed the majority of the duty statements for each of these positions so far, and we're working on our hiring strategies. Several of these positions are currently open with the recruitment process well underway. Other positions will be posted soon, and we will continue to maximize our recruitment efforts moving forward. So with the additional funded staffing, obviously that means we're going to have to identify office space to accommodate the increase. We're working with the Department of General Services Real Estate Division to identify suitable space. These discussions are ongoing, and we feel sufficient progress is being made in that endeavor. So the second biggest endeavor since our last meeting has been the procurement of our IT platform in order to support SB2. So if you don't mind, I'd like to invite Computer Services Bureau Chief Colin O'Keefe up to provide you a quick overview and update on this component, and then I'll continue after that. Colin?
Good afternoon. Colin O'Keefe, I'm the Bureau Chief in Post Computer Services, and I'll provide a brief update on the progress for the various technology components related to SB2 as of today. So just as a recap, at the March 2nd Commission meeting, the Commission approved staff's request to enter into a contract with a vendor to procure a case management system in support of SB2's various investigative review and storage components. Prior to the Commission's approval on March 2nd, law enforcement consultant and technical staff spent several months evaluating vendor systems for business suitability, and we identified a product called Mark 43 Case Management as meeting most of the business requirements created by SB2. Post has engaged continuously since late 2021 with the California Departments of Technology, General Services, and Finance by submitting business analysis plans and budget change proposals that Jackie just mentioned. And we sought technical approvals to move forward with a purchase. And finally, funding the project. As far as forward progress since my last report to the commission, on May 3rd, Post received project funding from DOF, and we awarded the contract to Mark 43 the following day. On May 18th, SB2 unit staff, executive staff, and computer services staff hosted an in-person kickoff with Mark 43 personnel to set high-level expectations and timelines. So we're fully engaged in the project as of May 18th. While we're still early in the implementation, staff and the vendor are reasonably optimistic we can be ready for the January 1st operational deadline. So that's the case management side. In addition to case management, staff continue to work on modifying internal systems and processes to support other workflow requirements of SB2. Among them including expanding EDI to accommodate non-post affiliated agencies, changes to notices of appointment, proofs of eligibility, suspensions and revocations of certificates, affidavits of separation, processing of felony and other serious misconduct records provided by the Department of Justice, and reporting requirements to the legislature and to the public. So most of the internal development is in the prototype stage. We're engaged with post LEC staff and Jackie's unit on a daily basis. And we're currently in testing and user acceptance for those internal components. So we're confident the internally developed processes will be ready for January 1st. And that is the technology update. Jackie.
Thank you, Colin. Does anyone have any questions for Colin?
Not necessarily in general, I have a question. Jason, okay. So you stated all of these components need to be in place to be ready for January 1st of 2023. Does Post feel that you're going to be able to meet these timelines with 127 positions and all the bureaus? And has there been discussion of possibly extending if Post is not ready?
That's a great question. So we have developed contingency plans for certain things, such as if our IT component cannot be completed in a timely manner, which we believe it will be. Hiring, we have a very specific hiring plan that we're currently instituting. There's no reason at this point that we anticipate that we will not be able to go into full implementation on January 1. However, if we do, we are building in some backup plans for the unforeseeable event if it's to occur. So I think we're in a good spot. Oh, short way of saying that. We're good.
Excellent. It's a lot of things to do in under 6 months.
Okay, thank you, Colin. I'll continue with my overview if that works. Okay, thank you. Okay, so staff has held 2 separate workshops with the different stakeholder groups. Also to create the content for the required 40-hour course for the Peace Officer Standards Accountability Advisory Board. As you probably know, that SB2 included a mandate that we provide a 40-hour course for the appointed members to that board. So it's expected that this course will be completed as early as September, and which will allow us to host some piloted courses before it's actually presented to the board. So it's our intent to make this course available to anyone sitting on the commission or on this body if they would like to go through that as well. I know you're not mandated by penal code to do that, but certainly if that is something anyone would like to do, we would welcome you to do that. And it's specific to the decertification process. So as of right now, Post is there's only been one member of that board that's been appointed by the governor, and that is Miss Lizzie Buchan. So this leaves 8 more seats to be filled. Hopefully we'll be hearing on that soon. Okay, moving on to other accomplishments that were
Jackie,
occurring. I'm sorry, Walt.
can I, and everyone else is probably up to speed on this. What's the composition of the board? I mean, the governor's appointing a person. What, if you could just mention that?
I can, yes. So 7 of the 9 members on the board will be appointed by the governor. 2 of them are appointed by legislative members. I can't remember the exact ones off the top of my head who's doing that. And 2 of the 9 can have a law enforcement background. The other 7 cannot have a law enforcement background. And there's a range of, I think, educators, advocacy groups, things of that nature. I can get you the specific language if you want, but that's the general makeup of the board. You're welcome.
What would be the process to be able to go through that procedure you said if we would wish? Would that be through,
The 40-hour course?
yeah,
You could just reach out to your post contact and we'll coordinate that with you. And we'd really enjoy, I mean, we're putting a lot of effort and time and money into it. So we would appreciate people going through it. So yeah, let us know.
absolutely. We should send it to the board.
Okay.
That's my opinion.
Thank you. Okay, moving on. Okay, thank you. So we continue to work with the Department of Justice to solidify the criminal conviction reporting requirement as stated in the bill. We're finalizing a memorandum of understanding between Post and the Department of Justice. We hope to have that completed soon. This is obviously a key necessity as we move forward, and something that we will rely heavily upon, I'm sure. So there's still a lot of unknowns, a lot of ambiguity out in the field as to what exactly is required of them pursuant to SB2 and how Post will relate to it. So we continue to do a lot of outreach to the field, and some of the ways that we're doing this and will be doing this include we attend law enforcement meetings to provide overviews to groups at whenever requested. So we've participated in many chiefs and sheriffs regional meetings, Cal Chiefs annual meetings, the training manager symposiums, background investigator conferences, and any individual agency who requests a specific one-on-one, we will do that and are doing that. So we're really trying to be available and make outreach to each agency as needed. We recently hosted 4 online live workshops, and each of those workshops targeted very specific areas of this legislation. It was phenomenal as far as I'm concerned. We've recorded that and we placed those recordings on our website. So anyone may refer to that and reference it at any time moving forward. And so during the live sessions, we had over 2,000 people participate in those live sessions. And since that time, the recorded versions have been reviewed online over another 2,200 times. So we feel that this is a very effective outreach that we've done. And it's something that people can go back and refer to frequently as needed. So staff just finished filming a newsreel style video with Digital Outpost last week, which will be an informational video that will be distributed for informational purposes. We continue to leverage our regional consultants to push the information out to the field. And we update the regional newsletters monthly to provide relevant information as well. So SB2 has its own page on the Post website, and we have an FAQ section of that. We are continually updating that and creating areas for resources that people can refer to. So as we discover and develop processes, they're going on the webpage as well. And then I think importantly, this is a really important component, beginning in July or August, Post will be doing detailed training sessions throughout the state of California regionally. So it's not going to be just an overview, rather this is going to be the nuts and bolts of what agencies are going to have to do with Post and to be compliant with our regulations. So we anticipate each of these sessions to be approximately 8 hours long to cover every aspect of SB2 and how it relates to Post. And so it'll cover honestly from the hiring requirement all the way through the end of an employee officer's career moving forward. So that's going to be a very, very important rollout once we do that. So we continue to meet with the Office of Administrative Law to work out the administrative law judge process. As you probably know that when an officer requests a review to go through the entire hearing process, it ends up for a full evidentiary hearing with administrative law judge before the commission will actually accept or reject that recommendation. So the challenge that has been in working with the Office of, Administrative Hearings, not administrative law, I apologize, is trying to help them and us determine the volume of cases that will ultimately reach them. And so it causes difficulty to help them with their staffing needs as well as funding. But we are continuing to work with them. It's estimated that the daily cost for an administrative law judge hearing is approximately $5,000. So funding for these hearings is yet to be determined. That was not part of our BCP. So staff is heavily invested in creating workflows and processes for each phase of this implementation. So we're hoping to have the majority of that done within the next 3 months so that we can properly train new staff as recruitment continues and to ensure that our processes are solid and tested and verified. And so since post jurisdiction over misconduct cases began on January 1 of 2022, earlier this January, the transition team has been tracking cases that have been made public through the media, which will likely require a review. So although reporting of these cases won't begin until next January, we're trying to be proactive in documenting these cases as they become known to us. To reiterate what Colin just told you, we have been updating some internal existing processes. An example that he covered some of mine, but I will give you an example that we are currently doing. So as part of the hiring and selection standards, if an officer who is being recruited by an agency has prior law enforcement, then that agency must look at the National Decertification Index to determine if they've been previously decertified in any other state. So in order to do that, they have to get the approval to access the index through Post. And the only way that we can give them access is if they are a registered member on the agency through their agency roster that Post maintains. So we've been running up into a few issues where agencies will hire civilian background investigators and they are not required to be put on an agency roster. Therefore, they haven't been able to get access to the National Decertification Index. So we have created a new classification within our agency roster, which will allow agencies to enter a civilian background investigator onto their roster so they can get access to that index. So, but it is kind of important to point out that these are only for the civilian investigators employed by a law enforcement agency. This will not apply to like private businesses or contract investigators. Again, it's only for the law enforcement agencies. So staff is working on what we're currently calling the Integrity Bulletin. That seems to be the common phrase throughout the states on what they're using. And what this is the public listing of all officers who have lost their certification due to separation, revocation, or voluntary surrender. So this will include the name of the officer, a summary of the allegations, and the date of the action. The information will be housed on Post's website and will be available, obviously, for public viewing. And finally, as you know, tomorrow is dedicated solely to reviewing all of the regulations created for SB2, both which have been amended and those that have been created. So there will be a total of 22 regulations presented to the commission tomorrow for review and for action. Of those, as we previously talked about, 20 of those went out for public comment in advance of tomorrow's hearing. And we did receive one letter of public comment on the proposed regulations from the ACLU. So that letter is attached to the agenda for reference for anyone who would like to look at that. And yeah, I just want to thank my team who's been working very diligently, all the Post staff who's been working very diligently to pull this off. It's been quite a monumental effort. And I couldn't be more proud of what our staff has done to get us to the point we're at. So having said that, that concludes my presentation, and I'm happy to answer any questions if you might have them.
Mr. Chair, may I say something?
Yes.
So I don't want to downplay your concerns, Board Member Spry. Please note that we recognize what a monumental lift this is. And by diverting that many individuals to SB2, we've had to pull from inside a post. So our regular day-to-day operations have been somewhat impacted, but we have no option to get this done. What we have, though, is a lot of outside of our agency partners, such as Department of Finance, who have really helped us to allow us to purchase Mark 43 and start to jump on the processes that we need to put into place. So it is an effort with the governor's office as well as other agencies within the state, and what every employee within Post has done, not just with SB2, but every employee with Post. And Mr. Allen, you talked about the funding portion of that. We do have it in the budget, but the budget still has to be signed by the legislature and it still has to go through the whole process. So although we anticipate that, it is not guaranteed. Thank you.
Thank you, Maria. I have a few questions after you, Jason.
Yeah, go ahead, Julie.
Okay. I'm gonna go back a little bit. Okay, so you discussed, I know, Mr. Allen, you spoke about the positions, and I want to help you out a little bit more. And I think I have a question following his request of that. Is there a deadline that the governor's office has to appoint these positions? And if so, would we be able to have this information for our next meeting, which I believe is in November?
Yeah, another great question. Yeah, there is no deadline specific in the language about appointing the board, and it doesn't have any information specific to that the 40-hour course must be taken before they start serving on the board or after. So there's no mandates associated with that.
Okay. So do you expect to have is there a conversation about being able to have information prior to the commencement of this program?
Mr. Chair, if I may. So the appointments, we've had some inquiries about appointments, both from public members, and we had some law enforcement officers reach out.
Right.
We've provided them. There is a link for the governor's office for the 7 appointments, an application link. We've informed the governor's office when we've had those inquiries. There's also a link for the Senate pro tem, who has one position that they appoint, and obviously the last one is for the Speaker of the Assembly. Right now, as it stands, we're just referring people to those sites and informing the governor's office when they do call. There is no deadline. I don't know how quickly they're going to appoint these individuals. The positive is that we don't anticipate that they will have work to do with reviewing these decertification matters probably till early part of 2023, whether it's February or March. Obviously, they're going to have to go through the 40-hour training course, but there's no huge urgency, at least at this point, for the board. But like all appointments, even with commission members, it's almost done behind the scenes and not transparent to us. Those are done inside the Capitol and they advise us, but we have not heard, where they're at with it, I guess is a good way to put it.
All right, thank you, Manny. And to follow up, is there a term applied to each position?
Yes, they are on a rotating 3-year term.
Any additional questions from the committee members?
Yeah, I just want to say that, man, this is a heavy lift. Jackie, you and your team have done a remarkable job. One of the questions I had was regarding the 40-hour training. I'm very much interested in the curriculum. I think it's wonderful. I wasn't aware of the 40-hour course. I think anyone that is going to play that kind of role needs to have some sort of training. Personally, I'm a little troubled by the governor, it not being a transparent process and the type of people that are potentially going to be appointed. and the biases that may come along with that. But I think it would be important to know what the curriculum was, because I think that may help us, may help law enforcement. That's the question I want to ask, the curriculum. What is in the curriculum for the 40-hour course?
So to point out that there are 4 areas listed in the bill that must be covered as part of this curriculum. I think it's excessive use of force, internal affairs investigations, agency level, disciplinary issues. I can't remember what the fourth one is off the top of my head. Even though my middle name is SB2, I do lose it once in a while. So, but yeah, so we are developing that curriculum right now. So we have
Okay.
we have a final meeting with SME groups. I believe it's in 2 weeks, I believe, to finalize what should go into that. And then we'll be creating the curriculum. Certainly that information will be sent out to this board and to,
And I'm sorry, it hasn't been developed yet.
no, oh,
Okay.
yes, no, we're still
Ask
finalizing it.
Oh, I understood it had been as well. I think I was with
Oh.
Mr. Allen on that. So
I'm
it's
sorry.
still not completed.
It's still not completed. We're meeting with the different group we have a group of subject matter experts that we've met twice. We'll be meeting a third time to finalize that curriculum, and then it will be developed, and then it will be piloted, hopefully by September for
I think
rollout.
I think that's going to be great, because people get appointed to a position like this, they're totally clueless about what's involved and the training that's involved, et cetera. So I think that's a great thing.
Yes, agreed. It should be very informational for everybody who serves on these boards.
Benning.
Thanks. Hello, 2 questions. Can you spell Elizabeth's last name for me?
Yes, it's BUCHEN.
And question number 2, does she fulfill one of the 2 law enforcement people's that have a background in law enforcement on the
She
committee?
does not.
Thank you.
You're welcome.
I just had a couple questions. And from the last meeting, I believe it was 1,000 cases that Post anticipates having to review. Is that still in the ballpark region, come 2023?
So that's one of those moving targets, right? So our final number that we have come up with that we believe is the best estimate is that Post will be reviewing 3,400 cases a year. So of those 3,400, how many of those will result in an action such as suspension or decertification? We don't know. And then of those that do result in an action, how many of those will request the formal review that will take it through the board and the commission and the ALJ? And that's the area we have really no data to pull from to determine how many of those will actually reach that point. But yeah, we're looking at probably 3,400-ish a year cases that we will be reviewing.
And then I guess, and maybe this has been discussed, and I'm kind of curious, obviously, those that work for Post, that's your full-time job, but the people that make up the commission, that's not their full-time job. I'm having done internal investigations and the briefings that take part, those can be 1, 2, 3, 4 hours. And we're talking about people losing their jobs. How do we anticipate the commission being able to review thousands of cases when they still have full-time jobs, and how does that get accomplished? And then how long does this process take to get those cases done? And I'm sure you guys have thought about that, but it just seems overwhelming when I think about that. And how do we go about getting the closure for the employee, but also ensuring that the appropriate action is taken for those that have done serious misconduct?
Sure. So that's a multi-part question you just gave me. So I'll start with the beginning where we're developing processes internally to have a very thorough and very fair and balanced review of every case, regardless if it's one we are recommending action or not action on, so that every case will be treated consistently throughout the state, regardless of what size of the agency, the level of misconduct. So we're hoping that between that with our legal team, once we do our review and we make a decision to take action on it, that the board and the commission will feel comfortable that we've thoroughly vetted that case prior to us making any decision. But then once it gets to the board and to the commission, those levels of review are similar to like a Skelly hearing. They're not going to be full evidentiary hearings. They'll have access to the entire case file for review in advance if they choose to. But the state and the officer will both have the opportunity to present oral and written arguments. There'll be no witness testimony or anything of that nature. So the procedural part will be fairly straightforward. It's going to be the review part by the commissioners and the board members as part of the agenda item, right? It's going to have to be all be public record. And then there should be some confidence moving forward that by the time it goes from the board to the commission and then to an administrative law judge, that case has been vetted thoroughly multiple times. And now it's going to the full evidentiary hearing where they're going to weigh the evidence and ensure that the standard that we have to support, which is clear and convincing, has been met. Then the ALJ will provide that finding back to the commission. So it'll come back to the commission for a second time, and they will either accept or reject the recommendation by the ALJ. So by the time that happens, and you consider the since these are all public hearings, the need to agendize and post and put all of this stuff out pursuant to Bagley-Keene. Each one of these steps is going to take quite some time before a final disposition is completed on these officers, and that's the reality of it. So it could take by the time we make recommendation on an officer, it could take 6 months before there's a final disposition, and that's a ballpark. So did I answer all those questions?
You did, yes, and I
Okay.
apologize for the
That's okay.
multi-faceted question. And then I see from the website that, and I'm curious, is it the commission, is it the administrative law judge, is it the advisory that are the 9 that are appointed, the 7 by the governor? I see it's not all or nothing. There can be a suspension of a certain amount of time, or it can be what appears to be you're forever suspended, I guess.
Correct.
And is there discussion on whose discretion is that for how long that suspension takes place?
Yes, so currently the way that it is written is that the board can recommend a lesser action than revocation if they feel doesn't meet the threshold of revocation. There's no guidelines on what that time period could be, other than we did write into regulation, proposed regulation, that it could not exceed 3 years, which is consistent with how long your basic training can be active, or before it goes. Yeah, you know what I'm saying. Inactive. Thank you. Sheesh. And then the same thing with the commission. So it's important to know the board is only a recommending body. The commission has the final say. They also will have that same ability to recommend a discipline, if you will, less than a revocation, which of course is permanent and irrevocable. It cannot be reinstated at any time. So they will have the authority to do that. We're going to lay out some guidelines that they can use tomorrow in regulation, just considerations when they're evaluating these cases that might help them with that. But we are not recommending, we're not doing a bell schedule, if you will, of this offense, you can get this suspension. So we're leaving that up to the commission at this time to make those decisions.
Thank you very much.
You're welcome.
Mr. Smith, did you have a question?
Yeah, you kind of answered it. Just to reaffirm my understanding, the board doesn't have the authority to revoke or suspend, just a recommendation. The commission has the ultimate authority. Now, you mentioned earlier a Skelly hearing, which is a pretty good example. And can that, during that commission's hearing, can that revocation or suspension be done there, or does it have to go to the ALJ, or is the ALJ more like an appeal to that?
The only way it would not reach an ALJ once it's started, this whole due process hearing, would be if the officer voluntarily surrenders at that point. Once it enters the review phase, it must go to the ALJ. So everything will go to the ALJ that reaches the board and the commission.
Okay,
Mr. Viramontes.
Or a real quick question, reference the statute of limitations. Is there a statute of limitations, kind of like pole bar? Usually you have a year.
Yes, this is 3 years from the time the agency notifies post. So it's lengthy, but when you take into consideration the delays on the back half with the appeal process, it accounts for some of that time. 3 years is the answer.
Thank you.
You're welcome.
One last thing. I wanted to, maybe I missed it. You said that you're tracking already currently incidents, I guess I'll call them. Who's your source or what is your source for these trackings?
Yeah, we're just doing that based off of media, things that we're identifying in public records, stories that come out through the media. We're not doing anything other than those that have become public knowledge, that we're maintaining that so that we can ensure that we cover that when our authority kicks in.
Is there a person or a committee or somebody who goes to that agency to confirm the media's source?
Oh, yeah,
Oh,
correct. Yeah, I'm sorry. If I gave you misinformation or didn't explain it very well. We're just doing those so that when the reporting period occurs, which agencies must report any allegation of misconduct, serious misconduct between January 1 of 2023 and July 1 of 2023. We're just going to use that as a reference to ensure that that information was reported to us, and then we'll go through the normal process. So it's nothing more than just documenting and tracking for next year's purposes.
Right.
If that makes sense.
thank you.
You're welcome.
Okay, thank you. Some good comments and questions. Any additional from committee members? Mr. Bernard.
So there are some built-in indemnifications in the bill, but honestly, I'm not overly comfortable talking about that. I think that we'd have to defer that to our legal counsel for tomorrow, if you don't mind. Unless Manny wants to add in on that.
No, not on that specific point. Obviously, we could be sued after the whole process in Superior Court. But there is no funding mechanism at this point, and we do anticipate some of those obviously filed with the courts. We anticipate, hopefully there's not gonna be that many after this arduous process of going through all these hearings and then an administrative law judge having the evidentiary hearing. Hopefully that will be kind of sufficient, but no, we have not created a plan in case we get sued. And I do have some other points, if I may, Mr. Chair. I don't know when the appropriate time would be.
Yes, thank you.
Is this now?
Yes.
Okay. So just to emphasize one of the points that Jackie mentioned, our responsibility as post staff is to bring matters to the advisory board that we feel are worthy of revocation, not of suspension. So it's their determination that perhaps it's not enough. So we will be bringing those matters to the board only the revocation proceedings. There are a number, I'm actually going back to Member Beauchamp's question about the volume and the workload on the board, on the commissioners and the ALJ. That has been addressed by some of the commissioners during the April 7th meeting, especially some of them who are very familiar with internal affairs investigations and Skelly hearings and have mentioned the volume of data that will need to be reviewed. Most of them, several of the commissioners spoke up and said, if I am reviewing one of these matters, I'm going to look at everything. I'm not going to just rely on a summary. And obviously they'll have access to all of the information, but they are very concerned about the volume. They made that known during the meeting as to the amount of work that they will now have, potentially twice, as one commissioner mentioned, because they review it before it goes to the ALJ and then after it comes back from the ALJ. So they have to look at it twice. They also, there's 4 commissioners that are going through the Senate Rules confirmation process. They made that known to the Senate Rules Committee, the volume of work that this could entail for them. And one of them specifically said that they anticipate coming back to the legislature potentially if there are issues that need to be addressed in terms of the volume They said, they would know a little bit more in 12 to 18 months after the bill or January 1 deadline comes to fruition. So that is definitely a topic of conversation for them because as we all know, there could be hundreds of pages and body cam footage and everything else that needs to be reviewed, and they want to look at all of it, which hats off to them for that. So just kind of summarizing a couple of the things that were already addressed. So as you asked, Member Allen, being a former state employee, we have to go through this whole BCP process for the legislation. That has been a challenge for us, not because of asking for resources, but the timing of it. The timing has really been a stressor for us because the BCP that we submitted, which was approved by the administration, the Department of Finance, and really to their credit, as Maria mentioned, they were phenomenal. They helped get us what we think we need. Was submitted in December and approved by the governor in January, but the money doesn't come, as we all know, till July 1. So the timing of it is a stressor in that we have to have 9 people full-time and additional staff helping here and there. It takes away from some of our existing resources and creates a timing stressor to make it all work by January 1. So timing has been a big stressor for us. The software solution has been a big stressor for us with getting Mark 43 on board in terms of it's next year's money, which isn't available yet. And we didn't have the funding in our budget, even though we have plenty of money. It's in buckets, as we all know, with bureaucracy, and we don't have money in that bucket, in the administrative bucket for the software solution. So Jackie and team and Maria had worked with Department of Finance, and they actually submitted a bill to get us funding this year for using next year's money, or advancing us some of the money. That took a significant process to make that happen. That just got approved. So that's why we were able to get the Mark 43 software contract in place with this year, even though the bill or the money hasn't gone through. So the software solution has been a big stressor for us. The other stressor is Member Spry mentioned is staffing. 127 positions to be hired in the next 6 months. Doubling our staff is going to be very, very difficult. I don't want to say impossible, but it's going to be very difficult. We were asked during the budget hearings how we were going to make that happen, and we were very frank. It's a labor shortage right now. We're feeling it in state government. We're going to do our best to get as many hired as possible. Jackie and Scott and others have been working on job duty statements, as I think Jackie mentioned. That allows us to advertise for some of these positions now, even though we don't have them. They're contingent upon the budget getting passed. So we've already started to do that with some of our positions to get them lined up for July 1. So we're trying to do as much as we possibly can with staffing. And then really the last stressor is educating the field, which I think they've done a phenomenal job with where we're at already. But we recognize there's a lot of questions out there, just like the questions you have. Some of the questions we don't have the answers to yet. And the field wants to know how the process works, and then they're going to need to know how Mark 43 and the submission process works. So educating the field is going to be a significant resource drain for us, probably in the fall of next year, as we start formalizing everything and moving it out across the state and regions, as Jackie mentioned, I believe starting in August. So there are a number of stressors out there. And then really the last thing that I wanted to mention is the execution of this. There are some things in here that we're just executing what's in SB2. So I think Jackie mentioned the Public Integrity Bulletin. SB2 specifically says you must publish the names of those officers that are decertified. So we're doing our best to execute what's in that bill to a T. I know there's at times been some pushback from some people in the law enforcement community just saying, or not in the law enforcement community, on one side or the other saying, well, why are you doing this? It's like, because it's in the bill. We're just doing what we're being told to do, what the law says. So I just want to echo what Maria, Jackie, and others and you all have said, to thank the team for everything that they've done to get us this far, this quickly has been a monumental effort. And then, as I mentioned previously, for all the people in the back room that may not be part fully of the SB2 transition team, they've all had to kind of suck it up without having team members there to help them do their work because they're on the SB2 transition team. So thank you, Jackie and Scott and everybody else. Thank you, Mr. Chair.
Thank you, Director Alvarez. And I'll conclude. I just want to thank you, Jackie and Scott, for the report. It was an excellent report and a lot of information provided. And also just recognize SB2 is a tremendous piece of police reform, and it's a huge change for all of law enforcement, but a tremendous ask post. And so we recognize that. I can tell you, I've seen some of the online workshops and heard very positive feedback from those workshops and presentations. I've seen your presentation at a couple of different conferences. And just want to really acknowledge your leadership, Director Alvarez and Maria's leadership as well, and all of the work by the post staff for putting this together. This is a lot of work, and we appreciate it, and you're doing a good job leading that. So thank you. Look forward to seeing you in Hot Visalia sometime in July and August, it sounds like, for live workshops. It's a horrible time to pick, but we'll welcome you there. But aside from all the work putting this together, obviously a tremendous amount of communication. And I think Post has done a good job answering our questions and putting information out there. And it's a lot of work just to do the groundwork, but then have to come out and keep all of us informed. We appreciate that. So with that, Assistant Director Sandoval, is there anything more on the agenda for tomorrow?
Yes. Thank you, Scott Campbell. You can vacate the seat. And Andrew Mendonça, you can come up and take the hot seat. And also Mark Nagel, please, and Katie Strickland. So the two of you or the four of you can address items G and H, possibly in a high overview level, or any questions that they have for you.
G and H, can you give me the regulation number?
I cannot, you have to know that by heart.
Oh, well, I'll start at the top then.
Okay, so that's 1203, 1204, 1206, 7, 8, 9, and 10.
Perfect. Okay. I'll start with regulation 1203, the proposed changes. Essentially, as I'm sure you are aware, Government Code Section 1029 has certain prohibitions that prevent you from being appointed as a peace officer. There's a relationship between Government Code Section 1029 and 13.510.8, which basically says if you are a prohibited person under Government Code Section 1029, you shall have your certification revoked. So the proposed regulation under 1203 basically just formalizes that and makes explicit the connection between those. The other regulation section, the proposed regulation 1204 deals with the cancellation of a peace officer appointment to a post roster if it is subsequently discovered during the course of, there's some other reasons, but fundamentally it's about if it's discovered during the course of a background audit that the person was not appropriately, did not meet the hiring and selection standards at the time they were appointed to the agency. It just gives Post the authority to cancel the appointment only to the agency roster. Obviously, Post doesn't have any legal authority to talk about the appointment of a peace officer to an agency. This is only dealing with the Post roster. And fundamentally, what this comes from is as I'm sure you're all aware, at the time of a new peace officer coming in with this new scheme under SB2, they're going to be appointed to an agency. That appointment is going to come with an attestation that says they have met all of the minimum hiring and selection standards up to and including Government Code Section 1029. And they're being issued a proof of eligibility based on that attestation. What this is this is designed to sort of close the loop. And if during a subsequent audit, we discover that there was not a full background done, there's something missing from the hiring and selection, it just gives Post the authority to cancel the appointment to the roster, which then will cancel the proof of eligibility. Otherwise, we're potentially in a circumstance where you could appoint, an agency head could appoint somebody to an agency, they could sign an attestation, they could be issued a proof of eligibility. And during a subsequent audit, we find that there's something missing. There's a lot of sort of due process built into this. That's by design. We certainly have no intention of just going in and running roughshod over agencies and canceling somebody out of a Post roster. There's certainly plenty of notice. We'll obviously work with the agencies to ensure compliance. But ultimately, if we get to the point where there's some insurmountable problem with the appointment, the only option we have is to cancel that agency roster appointment, which subsequently cancels the proof of eligibility. There's no prejudice there. If you fix the background issue, you can obviously reappoint the person with a new attestation and new proof of eligibility. So that's 1203, 1204, and then I would defer to my colleague for 1204. I'm sorry. Good. Yeah. Any questions about 1203, 1204? Great.
Good afternoon, Mark Nagel, law enforcement consultant with the SB2 transition team. Katie and I are going to go over a few regulations we have, starting with Commission Regulation 1210. That addresses the voluntary surrender of a certification. Section 13510.8 has been added to the penal code to include the ability for a peace officer to voluntarily surrender their certification. After a thorough review of SB2, it was determined there needs to be a regulation to identify the requirements and procedures for the voluntary surrender of a peace officer's certification. These would include establishing that any peace officer may voluntarily surrender their certification permanently, include the reason that a peace officer surrenders their certification, establish required information to be included on the voluntary surrender certification form. That would be the post number 2-358, and that will be adopted by commission tomorrow. And to comply with the commission's responsibility to report any voluntary surrender to the National Decertification Index and indicate the number of voluntary surrenders received by post to the Standards Accountability Division in the annual report.
Good afternoon. My name is Katie Strickland with the SB2 transition team. I'll be covering Commission Regulation 1211, which is the Peace Officer Accountability Advisory Board. So SB2 creates this new board, the Peace Officer Standards Accountability Advisory Board, and the regulation was created to identify the roles and responsibilities of the members of the board. This new advisory board to the commission was established to review the investigation findings of alleged serious peace officer misconduct and to make recommendations for the commission action upon a request for review from the subject peace officer. So Regulation 1211 addresses the following. 1, establishes the purpose of the board, the frequency and conduct of meetings. 2, establishes the responsibility of the board in reviewing investigations presented by the division and make recommendations to the commission. 3, allows the board to deliberate the facts in a closed session if necessary. And finally, outlines the board's responsibilities for notifying the commission, the division, and the involved officer or representative of reasons for a decision.
Next would be Commission Regulation 1212. This one's a little bit longer. This is the commission hearing on peace officer certification. So it was determined there needs to be a regulation to identify the roles and responsibilities of the commission in reviewing the findings of investigations of alleged serious misconduct of peace officers and determine appropriate action regarding certification. The roles and responsibilities of the commission in relation to peace officer certification include the commission's authority to suspend, revoke, or cancel any certification issued by post, the responsibilities of the commission in reviewing the recommendations of the board, and if adopting the recommendation, the vote shall be required a 2/3 vote of the commissioners that are present. Adopt procedures if the commission reaches a different determination than the board. Establish the evidentiary standard of clear and convincing evidence. Allow the commission to deliberate the facts of the case in closed session when applicable. Establish responsibilities of notifying the division and the involved officer or representative of their recommendation for action and provide an explanation. Establish procedures for a formal hearing before an administrative law judge, including notification requirements. Establish the commission's responsibility to publish the names of peace officers whose certifications have been suspended or revoked. And establish the commission's responsibility to notify the National Decertification Index of peace officers whose certifications have been suspended or revoked. Any questions on that?
And the last regulation is Regulation 1214, which is the annual reporting requirements. So Commission Regulation 1214 identifies post responsibilities to prepare annual reports on behalf of the board to include the activities of the commission, the board, the division, and post participating agencies pursuant to Penal Code Section 13-512. So this is new responsibility of the commission, and post has determined it's necessary to codify such factors to provide clarity for the regulated public. So this regulation addresses the following. 1, subsections A1 through 10 identify the items that must be reported annually pursuant to Penal Code Section 13-512. And also the annual report must be made available in a manner that allows it to be accessible to the public. Any questions?
Any questions from the committee members on those? No, thank you. I don't have any further questions. That was a good high level overview. Oh, very much.
Sorry about that. Maybe I missed it. It's under 1210 where you discuss voluntary surrender certification. Are any of those things going to be posted anywhere?
As in the forms, the form.
Correct. Prior to, let's just say, being decertified, the guy just beats you to it and says, hey, I'm submitting my voluntary.
Yeah, they'll be available on the post website.
One more. Would this person be added to the integrity list?
Yes. Yes, they would be.
Even if it was voluntarily, it'd still be under that same list. It wouldn't be under a different list.
Correct. That anyone who voluntarily surrenders, is suspended or revoked will be added to the integrity list.
It's primarily the in lieu of termination portion that we're trying to capture.
Okay, any additional questions?
Understood.
Julie?
Thank you. No, just thank you.
Okay, thank you for the report. No additional questions. Appreciate it.
And just as you go back to your individuals who have put you in this position, if you can let them know that post did not write SB2, that we are just trying to work it out because we are still, poor Jackie is getting beat up in the field as she goes from location to location, thinking that post has implemented this because we're mean people. So I just want to kind of put that out there. And that's all I have for you, Mr. Chair.
Okay, thank you. And continue review of tomorrow's post-commission meeting agenda for May 25th. All the items tomorrow, we've covered most of them in this overview, have to do with SB2 implementation and regulations associated with. Are there any additional comments or questions from the committee members for the commission tomorrow on those items? If not, I will move on to the post-commission meeting agenda for the regular meeting on May 26th. On this agenda, for the regular agenda, we have a number of consent items 1 through 5, fairly standard business related to post. Are there any questions or comments related to those 5 items on consent? Not. We also have the Finance Committee report, which has been provided, and that meeting, I believe, is later this afternoon or tomorrow afternoon, 3 o'clock. Item number D is a Basic Training Bureau report on minimum training requirements for district attorney investigators. Are there any comments or questions related to that item? Not. Item number E is Management Counseling Projects Bureau with regards to legislatively mandated courses. Any additional questions for that report or comments for the commission? Item number F has to do with peace officer background investigations and Commission Regulation 1953 and 55, as well as peace officer psychological evaluation. This has to do with the bias assessment framework implementation, as well as proposed addition of social media checks for peace officer candidates. Any questions or comments to provide for the commission on this item?
Just one quick question on that, and I apologize that I've forgotten on this. With this mandate, and I believe it does, but I want to just verify that anyone applying to be a peace officer, they're required to provide information so their social media accounts are viewable and not private. Is that correct? And is that what we're talking about?
Hi, Melanie Singley, Selection Standards Program Manager. Not necessarily. So there are several provisions in state and federal law that may prevent agencies from looking at private accounts. This is strictly to do a social media search. So currently that'd be public information. We are in the process of developing guidelines that will include state and federal laws that are applicable and providing those to the agencies so they have a means to determine how best to approach this requirement.
But this wouldn't override that state regulation so that you did have access to take your Instagram account or your Facebook. And I know the idea is to find, if someone's posting things that would disqualify them from the hiring process, be it of a racial nature, sexual nature, things of that manner. I'm assuming a lot of people aren't making that on their public profile, but they're making that on their private accounts. Is this the idea that we would, or is there talk of amending the law so that we would have access to those things? Or is it just putting in regulation what you can and can't look at?
Yeah, the regulation itself doesn't specify looking at private social media accounts. I think you're referring to Labor Code 980, which does not allow them access to that information. And that specifically was developed based on using a correctional officer as an example when that was implemented. There has been discussion that it may not apply to public employers because the Labor Code often doesn't. However, there's kind of that gray area where legislative intent comes into play, right? So we're not asking for people to look at private social media accounts. However, any public social media is available to anyone. That would be at least a starting point. And then from there, there is talk of maybe looking at the legislative process and changing that. There was a recent state audit that was done, and they are recommending social media checks of applicants as well. And they had made a recommendation to change that law specifically as well.
And was that from the RIPA board recommendation on that?
No, this was a state audit that was just done. The report was released about a month ago.
Okay, because I thought I read something recently also on a RIPA board recommendation as it pertains to finding those things. So I didn't know if that was.
Yeah, I wrote RIPA is they're the ones actually recommended the social media search. We worked with them on this particular these new regulations that we're putting forward to the commission. We worked with RIPA. One of the recommendations was a social media check. And so, yes, they're very well aware of that as well.
Okay, thank you.
Any additional comments on this item? Not, we'll move to the final item, which is from Training, Delivery and Compliance Bureau, item G, minimum standards for training with correction of firearms PSP topics. Any questions or comments on this item? Okay, and that concludes review of the commission meeting agenda. We had no additional presentations for this afternoon, and I will move to advisory committee member reports. Are there any committee members who would like to provide a report from their respective representations? Mr. Allen?
Not at this time. I just want to say what a pleasure it is being here representing the CADA organization, and we really look forward to working with you post and being involved in the process.
Thank you. We're happy to have you here. Welcome. Mr. Viramontes.
Nothing to add.
Mr. Fry.
I'm good.
Mr. Benning.
Nothing to report.
Chief Bosham.
Nothing to report.
Schmidt.
Nothing, thank you.
And Mr. Bernard. Nothing. I don't have anything specific. Obviously, there are a number of items that I think we'll see on the legislative review tomorrow that are obviously concerned all of us and Cal chiefs. One of them particularly with regards to interrogation of juveniles under the age of 25, which I'm sure will have some impact on post with regards to training requirements, with regards to interview interrogation tactics. But that is one we're obviously watching, as well a host of others, but nothing as significant as SB2 right now. So. With that, we will move on to commissioner comments. I believe I saw Commissioner O'Rourke present. Any comments, sir? Okay. We have no old business today, and I will move to new business where we would need to receive chair and vice chair nominations. And with that, I will turn the floor over to Assistant Executive Director Maria Sandoval.
I just want to thank Chief Salazar for stepping in today. but it is time to elect a new chair and a vice chair. So since we have a quorum, does anybody want to make a motion or nominate themselves or a fellow advisory committee member? Yes, Mr. Viramontes.
I'd like to make a motion for Jason Salazar to retain that seat. He did
Oh,
very
boy.
well. And you're welcome, sir.
Chief Salazar, how do you feel about that?
I'd be honored and happy to do it. Thank you.
Okay, we have a chair now for the vice chair.
I'll help them.
Okay, so Julie Spry is nominated to be the vice chair. Do we have a second to?
I'll second that.
Okay, here we go. Thank you very much for that. I appreciate that.
You're welcome. Take a vote, team.
That concludes our items for new business. With that, we'll move on to future meetings. The next upcoming committee meetings will be held November 30 to December 1st, 2022 here at Post Headquarters in West Sacramento, followed by March 1st and 2nd of 2023 to be determined. And then in June 7th through the 8th, 2023 here at Post Headquarters again in West Sacramento. With that, that concludes the items for today's Post Advisory Committee meeting, and I will adjourn the meeting.